We resume recording. We're back on the record. Okay, we're back on the record. Mr. Cercio, your appearance and bar number, please.
So, Bob Cercio, CPR, bar number 5247. My apologies for the sign-on. I was signing on Zoom. You know, it's hard for me sometimes to keep up with which direction we're heading.
Okay, we appreciate you joining, counsel. Just some preliminary matters. I do have the DA and DFS here. Normally I take them first, get an objective report from them, the status of their referral, and then I typically just release them from the case. So I'd like to get their report first. But before we begin, I believe there is a letter that was sent to the court from Hope Counseling. And Crystal Ripple, I'm not sure if she's still Preston's therapist, because another therapist was assigned within that office, who is now seeing Preston, because maybe Crystal moved to a different position. Maybe Ms. Ripple can explain that to the court.
Yes, Your Honor. Preston is with Hannah Hartman. She is his current therapist. And I transferred the case in June due to her specialty in therapy. It's a specific type of therapy.
Is Hannah Hartman available today?
Yes, Your Honor.
Are you just sitting next to Crystal? I can't see you.
No, I'm here. Sorry, I don't know if my video.
Oh, there you are. Okay, all right. Let me see. You are listed as a on here. Okay. Very good. So we did receive a letter. I didn't read it. I don't read things unless perhaps all the sides should read it. I don't want to look at anything one-sided, obviously. And so I want to know from Hope Counseling the intent of the letter. Was it something the court requested, or you voluntarily provided an update on Preston?
It was something the court had requested.
Okay.
We provided updates as to the process of where everything is at with Hope Counseling Services.
Okay. Now I haven't looked at it, but it is here available in my email. We have parties here who are not represented by counsel. If I had two lawyers on both sides, I would normally distribute the letters under a confidential gag order. But are there any concerns with respect to the child? If Mr. Cercio got a copy of that letter, if Ms. Furtick and Ms. Lay got a copy, and then that letter, we can't give an actual physical copy to the paternal aunt and the paternal grandmother, but the content of the letter can certainly be read to them unless there is something of any concern. So I'll hear from Hope Counseling. Based on the content of the letter, do you have any concerns with people having access to the letter? We do keep it under confidentiality, which means it's not, the contents are not to be distributed, obviously, to the public, because it's for the protection of the child's privacy, etc. So it's sort of treated like a medical record. Are there any issues with that?
I don't have concerns about the letter that I wrote being distributed.
That was the one
I don't have concerns for Preston's safety.
Okay, so neither judge included, I have not seen the content of the letter. That letter will be made available to counsel, but I think I can, just to streamline things today, I think we can get a verbal report from you, but I will let CPS go first about a new investigation or referral. They can just objectively tell me date of the referral, nature of the referral, what action has been taken. and then they're free to leave the hearing unless anybody had a quick question with them, or they can stay on and listen to the Hope Counseling's verbal report to the court on the status of Preston's therapy. We are here on the mother's motion granted on an order shortening time regarding a recent incident involving a nail and a hammer, I suppose, in the child, issues regarding self-harm, potential self-harm, and we're here to address that today, and the status on the paternal family members' visitation. And if everybody should have been served. I don't know if you had access to that, but the paternal family filed some photos of the child concerning that weekend visitation that was resumed. Photos at the lake, etc. They were color photos, so make sure to let me know if you don't have access or you were not properly served with those photos, plus, I guess, a opposition and a statement in opposition to the motion to suspend paternal family's visitation. Everybody get a copy of the paternal family's response?
Yeah, okay, I would be helpful for the paternal. We did not receive any photographs.
Yeah, they're filed in Odyssey, so you and Mr. Sorcio and Ms. Berman have access to Odyssey or Wisnet, whatever you call it. They are filed there. We always have trouble with photos properly serving, or if you're on the e-serve list, I don't have time to go over that, but I do want to mention that they have filed a response. And notably, we're going to discuss this in a minute here. Part of the response includes questioning the therapists and obviously their concerns about bias, etc. But we'll get to that. Let me hear from DFS first. So that would be Yvette Howard from CPS.
Yes.
Okay. Just briefly summarize, when did this case become assigned to you and the nature of the allegations?
It became assigned to me on August 17th with the allegations of physical risk for the child.
Okay. Yeah, go ahead.
I was going to say, basically, the referral stated that during the weekend visit that he had with his aunt, he was instructed to grab a nail and harm himself with the nail by someone who was stated to have been at the visit. The nail person was his great-great-aunt. But after speaking with family members, it was found that the great-great-aunt did not attend that weekend visit. And when the department did question Preston in regards to, where he got that information, he states that Stacy saw it happen, but Auntie Boo Boo told him to hurt himself, and he would not give further information. That there were marks and bruises from nails seen on the top, but he did have like a 1-inch scar on the top of his head, but him and his mother stated that scar came from he had hit his head on a speaker on the bed at his cousin's house a few days prior to me seeing the family.
Okay. And the status of the case now, ongoing, will you be doing an NIA?
It's still ongoing. I have one more person to contact.
And who is that you're trying to contact, Ms. Howard?
It's a lady that they gave me, oh goodness, what's her name? Maureen Slater.
That's the maternal grandmother.
Yes.
Okay, and have you been able to reach the maternal grandmother?
I will check the notebooks.
Okay. All right. Any action taken by CPS, like a safety plan, or discussion with both sides of the family?
No safety.
No. All right. Does any of the attorneys, the Bread and Blight Toronto family, it's William Spirit, have any objective questions of CPS? They're not testifying today, they're just giving me a status on their case.
This is Officer Shea speaking at the Guardian Ad Litem. I do have comments about the conversation with the child on Friday, but I don't know if it's appropriate to share that with CPS or whether I just want me to provide what I found out on Friday.
Well, since you mentioned that, I think it would be okay with the court if you give me a verbal report since it was recent, as any additional information may be of assistance to you.
Thank you.
Sure.
Yes. Thank you. So I spoke with Ms. Hartman on Thursday, consistent with the prior directions of the court to speak with the counselor and to meet with the child at least once before the next hearing. I was not able to coordinate a visit with the child while he was with his aunt Stacy. It was just this past Friday that I spoke with him. I spoke with the child for about 40 minutes, consistent with the prior phone calls that I've had with the child. When I say phone call, I mean a Zoom meeting with the child at Attorney Lay's office, the child being left alone in the conference room, and for me to speak directly with him. I asked him about school. He said he was not in school. I don't know whether he meant that moment or whether it had not started yet. He was his usual playful self, age appropriate, I believe. I noticed the bump on his head. It was a little mark above, I think his, I can't, more towards the middle of the forehead. He said that he had run into the edge of the speaker at a birthday party that sounded consistent. I didn't think anything more than just that little kids fell down. It was that type of event. I asked him directly about who was Auntie Boop, and he said that was Aunt Stacy. He identified her. When I asked the question, I did not mention any other adult names. I just said, listen, I need to ask you a question. Who is Auntie Boop? Oh, that's Aunt Stacy. And he continued on. It seemed like a genuine response. But again, I couch all of this with, it's very difficult to assess the veracity of the child over a Zoom phone call. He volunteered that she told him to hurt himself, and he almost, quote, did a big no, close quote. But then I did a big yes, yes, I'm not hurting myself. We spoke, with the child. I try to bring up as many topics as possible so we're not going one point at a time. I asked him if he had any concerns about going to visit Aunt Stacy. He said he's not afraid of going over there. He would like to have lunches with her, would be home by dinner. He liked the idea of going to a McDonald's playland. I asked if he needed anything. He again requested, a PlayStation 4 game, Lego Harry Potter, something that's age appropriate. So I don't know where the court wants to go with this. For the last time I spoke with the child, it seemed very coached by the maternal grandmother to say a certain thing, and that was reported in their last letter to the court. This time it was a 180, but he said it so casually, it did not feel coached. I'm not sure what to do with the information in terms of the recommendation. That conversation took about 40 minutes from end to end. I'm prepared to answer any questions you may have.
Okay, thank you for that report. And with that, I don't know if the DFS is still on the line. Anybody else have any quick questions for CPS? They're going to continue with their case and we'll continue to monitor and get updated records. Okay, no questions. Ms. Dorman, may I ask you, we have two parties who are co-pros. They are parties to the case on this grandparents visitation, family member visitation, and or a actual custody request. Are they able to get CPS records themselves if they email the DFS office? I know that parents can get them themselves. And if there are attorneys, I give them to the attorneys under a gag order, confidential order. So if they want to get CPS records, yeah.
It does depend if the investigation, if Yvette's current investigation names one of the people that you're talking about as the alleged perpetrator, then they would be entitled to certain information, yes.
Okay. They even send it to the court redacted, and so they will do the appropriate redactions, and they need to contact them if they want to get a copy of the records. But
it'll be significantly more redacted than yours even, but yes, based on the statute, NRS 432B 280 and 290, as an alleged perpetrator. So whoever is the alleged perpetrator in the recent case should be the one to make the request. They would be entitled to certain information.
Okay, thank you for explaining that policy. And my policy is the court's redacted version. I do give those to attorneys, but they're not allowed to give the copies to their clients. And if it's a guardian item, obviously they're officers of the court as well. So they're entrusted to keep the confidentiality and allowed to keep the copies of the records in the phone. Okay, with that in mind, then thank you, CPS and DFS and district.
I have a question. So I'm confused. So who's the proposed allegation on?
In case you want to request records.
Well, is it on me? Is that what this is about? Yes. Because there's no answer to Google. That's it. There's no very hard, there's nothing. And this is, you know, if we look at the records, this falls in line with Alyssa's history of making false allegations to prevent the paternal side of being involved in Pepsi's life.
My question to CPS is, Dorina Slater is not collateral for our side, and we have obviously finished the investigation with our side, because anything Dorina Slater could say about either of us is hearsay since we have no relationship with her. And I would like to ask CPS, are you closing the case on Stacey Cantor, who is supposed to be the alleged perpetrator, under the guise of anti-Google?
Ma'am, we're not going to answer questions about our investigation. You don't determine when our investigation is finished. You don't determine what we do, who's a collateral resource. We're not going to be answering to you about our investigation.
I'm simply asking if they're going to close the investigation. I'm not asking about semantics.
It's premature. They have an ongoing case. They have one more interview to do, and how they proceed further, we will just keep an update on that. But apparently, it's still an open case.
And that is until the investigation is done and we have all the conclusive evidence, because we're jumping the gun to change the status quo and deny her visitations based on an allegation that is false, number one. Number two, it's an ongoing investigation. Nothing is concrete. There's no determination, and nothing can be changed without a determination. Also, it is not detrimental for her to see the child, because the child has a good relationship with her, and she is from the child's side.
We're going to hold off on the arguments. Hang on. We are going to argue whatever you guys want to argue. For purposes of where we're at on the hearing, I am going to I think your question was answered, Stacy. If you want to get a copy of the record, you should be able to get a copy or a redacted version of the CPS records. And you may keep that for your file, and you just let them know. Ms. Dorman, I believe if you let them know there's an upcoming court date, and we'll send you a copy of the court minutes from today. They do try and expedite the request. That's my understanding, so that they can have the record before their next court hearing. Okay, thank you very much. I will now release the DA and CPS after getting their report. They're ongoing. The finding today, and I've written in the chat box, it is an ongoing investigation. They have one more interview to do. Unless they have other interviews or other information they want to gather, then they should give us an update next time. And so we'll continue to monitor that and obtain the records once they get updated. Anybody have any questions as far as TPS, DFS, or the district attorney? Because I'm going to release them, and then we're going to argue the motion to suspend the visitation. Yes. Marianne, you have to unmute yourself. Let's see, did we lose me? You have to unmute yourself. Okay, the video went off. I think they can still hear us. They have to, might be their internet connection, but they're muted. I can't unmute them. They have to unmute themselves. Okay, so while we're waiting on them to come back, court will obtain updated CPS records. We'll provide to counsel the preferred parties. Okay, are you back? We lost you there for a minute.
So I just want to say something because I met with Yvette, and this allegation is on a fictitious person, anti-Boo-Boo, who doesn't really exist. So, I mean, I really saw him for, I took a look Friday, dropped him off on Sunday. I showed the picture.
Yeah, the question is, can you get a copy of the DFS records? Ms. Dorner, are we having any issue with that if paternal aunt and paternal grandmother wanted to get a request because of a reference to an anti-Boo-Boo? I think it's V-O-O or V-U-V-U. Not Boo-Boo. It's a V, as in Victor. If they are somehow the subject of that reference, whether it's proven or not, would they be able to get the records, Ms. Gorman?
Let me ask Yvette, when during the course of your investigation, were you able to determine who the alleged perpetrator was?
It stated that it's an anti-Boo-Boo. And from the information that I get, an anti-Boo-Boo, this person was not in the vicinity when this happened.
So you don't believe anti-Boo-Boo to be Stacy? Or your investigation didn't reveal that?
No, when I spoke to Preston, that was never indicated that Stacy was Boo-Boo. He specifically told me that she was an old lady and she was 99 years old, and that was his great-great-aunt.
Okay, then to answer, you're absolutely right, Judge. She would not be entitled to any records, and we would not be allowed to release those.
Okay. Since DFS will not release the records, and I know there's an area of confidentiality, one option that we would have is for them to come to the courthouse and review the records, but they're not allowed to have a copy, and they would have to sign a confidentiality agreement or order. So, in case you have any issues with that, that would be my plan, is if they want to review all of the court's CPS redacted records, they can come to the courthouse, sign an agreement, and read it, but they're not allowed to have copies. Okay, so, and we'll do this. Okay, I'm going to put something in the chat box here. she'd be unable to get the records. The paternal aunt shall be permitted to come to the courthouse to review the CPS records. Okay. Under a confidential order. Alright, so she'll sign one of those agreeing that, it's not to be disseminated to the public, and she'll have full access to the court's CPS records to date. If she wants to call ahead in my office and then come out to the third floor of the courthouse and sit there and read all the records so that she can prepare her case. Alright, thank you, DFS, and the District Attorney's Office. You're welcome to stay on if you want to listen in, or you may leave if you have other matters to attend to. So let's proceed with the mother's motion. It was heard on order of short time today to suspend because of the nail and hammer incident. We now have information from the GAL. We have information from CPS DFS. All right, Ms. Lay and Ms. Burdick, I don't know which counsel is going to argue their motion. It's been read. They've obviously filed an opposition to it, and the court will decide what will happen with paternal families' visitation, which recently resumed, probably less than a month ago. So let's proceed. Okay.
Thank you, Your Honor. Linda Lay on behalf of the defendant of the former. I appreciate the time to do it on OSP. We do have a therapist, Hannah Hartman, the videos. I will make it short because I would like to refer to their expertise in terms of, not expertise, but their report and the status affected right now. As you recall, last month we reviewed visitations with maternal and safety cancer. After the visitation, there was a report to CPS of the reason why the report has been open. The has been open. The IOT is very important that the child is kept safe. It is in the best interest of the child to be kept safe. The mother has had full legal custody and full physical custody for the last 6 months. It was really well with therapy this past few months since February. And due to that, Crystal was the original therapist, but she was a trauma therapist, and she transferred the case to Hannah Hartman as Ms. Whipple AKA because she has expertise in therapy. Based off of the information provided by the therapist, and I was not privy to the extent, but from the information I did know, President was able to assert himself and was told by Auntie. I mistakenly heard it as Auntie Boo-Boo, so I apologize if it's Auntie Boo-Boo. But because of the nature of what he was telling Alyssa when he got to the car and she picked him up, it alarmed us. And since then, we did not continue and resume the visitation. So we have missed 2 visitations already since last month. But I will refer to the therapist in terms of the nature.
Okay, so mother spoke to her lawyers, and she has not given a visitation based on the child telling her that he had a nail and the circumstances surrounding that nail. Is that correct? That somebody told him? I'm sorry, I don't want to put words in the mother's mouth, but apparently the child approached, from what I read in the paperwork, the child approached the mother and said, I have a nail and I don't want to hurt myself. And I guess the mother made an inquiry with the child, and what was the child's statements to the mother? That it was anti-Boo-Boo, or was there any reference to that? Now, let's see, what exactly did Preston, out of the blue, comes up with you and gives you a nail, and he says, I don't want to hurt myself?
Well, he
Stacey asked that man through the drop-off at Dr. Deco's office, and we went down and saw Dr. Deco for about 30 minutes, and then I picked him up on Sunday, I think it was about 6:30, and the first thing he said when he got in the car was, Auntie Stacey did not tell me to hurt myself this time, it was Auntie Ruby. He told me to take a needle and put it into my skin with a hammer and say, Mommy told me to do it. 2 days later, he came up to me with a nail and said, Mommy, I don't want to do it. I've been thinking about it. I don't want to hurt myself. Please take this nail. The day after that, next to his bed, I found a nail underneath his books that he reads that are next to his bed. So at that point, I went to my house, I went and made sure there was no more nails or anything like that. And I talked to Miss Hannah Hartman, which was his therapist, on Friday. And that was when she spoke to Miss Day. On another occasion, the child said, I don't want to hurt myself. Was there any reference that he actually presented an actual nail? Yeah, he handed me a nail. That's right. I don't want to do this. I'm afraid I'm going to hurt myself. Please take this nail. Okay. All right. Anything further, Miss Lay?
So, Your Honor.
All right. So, I will hear from the Aunt Stacey in response to these allegations.
Yes, Your Honor. So we agreed a work-out arrangement with Dr. Deco to have the exchange done at her office. I was supposed to arrive at 5:30, and Melissa wasn't supposed to arrive until 6 p.m. She came early and made sure. The reason I did that was because I wanted him to go directly from me to Dr. Deco without her influence. Well, Melissa made sure that she was at the office the same time that I got there, and went out of her way to make sure that she had contact with customer before going into the office. I left, and this is the last thing I know when I get a call from Linda saying that person something about a hammer and a nail from Auntie Boo or something like that. This is a ridiculous allegation. Like, this is not something a 7-year-old will come up with on himself. This is Alyssa all the way around. Like, she's done this numerous times. Like, I have a whole CPS situation, or a whole CPS table of contents. Look up date stamp number 778, 885, 872, where Alyssa is making questions there about Sean. November 17th, or November 16th, Alyssa trying to blame Sean for a burn. Preston is telling CPS that long cigarettes on his back. So CPS says that Alyssa's coaching based on 971-855. The list goes on and on. And I have about all these pages from the CPS. Do you have the folder in front of you that we can turn to these date stamps? This is her cycle. I literally saw him for one weekend, and based off our last hearing, this is exactly what she does. She does not want us to be involved, and she's using the counselors and CPS to manipulate us. This is over there. Was he hurt?
Okay. So I read your response in your paperwork, and obviously we do have counseling, the 2 therapists present here, and I'll allow them to respond, but they might not have, obviously, the opportunity to read your statement about them, saying that they are either biased or in cahoots with Mom. You question their independence, and that's kind of basically it. But is there anything specific you identified that would cause concern to the court that they are not being objective? Because their role as therapists obviously is to act in the best interest of the child, and a therapist's motto is obviously do no harm, and what you're alleging against them are very serious allegations. But in terms of, and I'm pretty sure they're going to say something in response to that about them and how they're handling the therapy and how they came about, etc. We'll ask those questions of them. But is there anything else specific why you question their
yes,
advocated?
Even before
I had even met her, she was biased towards Alyssa, even before when this case first started. Because Alyssa is telling Presley to repeat these stories about how Sean's making her look at PP as like a lollipop, and she's repeating the same exact stuff about how he died and stuff like that. So she was already biased. Then I personally met with Crystal, and she personally told me that she was fearful for Preston with Alyssa. Not to mention in the last hearing on February 14th, she was on the stand and said, yes, there was a cigarette burn, and it occurred the weekend that he was with Alyssa. Also, I have text messages from Katie confirming that Alyssa sent in that burner, and he was with her. I was nowhere around. Crystal initially told CPS that he came from my house on December 9th, which was not true. So I don't understand why she was biased towards Alyssa, but they're covering up for her for some reason. They know, not to mention, the teachers have all expressed concern about Alyssa's mental stability and her, so I just don't understand, I don't know.
And Your Honor, you have said that we called CPS 30 times on Alyssa. We did not call CPS 30 times. Doctors, teachers, lawyers, school officials, and neighbors have also made CPS reports on her. So it was not, I have made personally 3 phone calls. Sean made about 4. Stacy's made 2 out of those 30. Also, they have said that yes, they are biased, the counselors, because Alyssa Plummer has convinced them that I'm a convicted child abuser. Let me ask Crystal Whitley. Crystal Whitley, am I a convicted child abuser?
Okay. Hang on. We will. Okay, thank you, Stacy. All right. Now, we'll get some input from the counseling here. Ms. Whipple, would you like to go first, and I'll hear from Ms. Hartman regarding these allegations? And we're not in a trial, and nobody's subject to cross-examination here, so, and you may speak freely on what they're alleging. You may not have read their accusation, but I think you kind of gather what they're alleging here. How did you come about to becoming assigned at Preston's therapist? Was that through a CPS referral or through mom just seeking out your office? I may not exactly remember.
Preston came to our office as a referral from CPS stating to mom. So mom came to our office from herself, stating that CPS had suggested that she get therapy for her child. But it wasn't a referral from CPS or anything, it was just a suggestion that she decided to implement.
So Hope Counseling gets a lot of referrals from CPS?
We do.
Okay, understood. And so your clinic was the name given, and mom made an appointment to see you, and Preston became your patient. Is that correct?
Correct.
Okay. And you treated him for, what is it, over a year or longer?
I treated him over a year.
Okay. And did you want to say anything in response to this concept of bias? You know, this is a highly contested case. Obviously, there's a lot of finger pointing, but in terms of your role as the therapist, and you know, the therapist's motto is do no harm, obviously. So you know that. I'm not a therapist, but I just seem to know that. Especially in my experience, wanting to gamble for and addictions and whatnot, it's the same all around. So your job, obviously, is to stabilize the child, and it's to obviously treat the child in a manner that would obviously not do him any harm, and obviously help his mental health and well-being. Correct?
Correct.
And so, from your perspective, and why the other side believes that somehow we're biased with the mom, what is your response to that allegation?
I believe that we refuse to do no harm to the child, and that their own biases against us, that we try to be as neutral as possible. And with this case, there's been so many things that have come up, and things we get so much information from so many different people that we try to be neutral as possible.
Okay. And obviously we have, just like lawyers, right? We have ethical duties with licensing and everything, and we deny that there's any bias going on between the mom. And how would you know that if people, their case is so personal to them, so, and you've seen the two sides of the family, obviously warring in the courtroom and how contentious it is. Were there any instances where you've had to redirect the mother for injecting herself too much in terms of not letting you be able to, do the therapy for Preston, do your job and helping Preston? Has there been any lack of cooperation or any redirection of the mother?
The mom has been 100% cooperative with us throughout the whole case. Even when she didn't like what we were doing, she was always cooperative, always assisted and made sure that customer got therapy. So I don't think there was any non-cooperation with her.
Okay.
Okay, Your Honor, can I ask a question? So, firstly, you told me that she had kicked Cody, I think is how you say her last name, out of her house and will not allow her to do the visitation. How is that being cooperative?
Wait, can you slow down and say that one again, Stacy?
When I had met with Krista on February 5th, she told me that Alyssa had kicked Katie, the Indian counselor, out of her house, made her cry, and would not allow her to resume her visitations with Preston. So how is that being cooperative?
Yeah, go ahead, Ms. Wilka.
No, I know what I'm talking about, Stacey. In that case, she had asked that Katie leave, because Katie had a key to her house, and she had asked for the key and asked for Katie to leave. But when I had spoke with Mom stated that she was willing to have services with Preston, just not in her home. That she's still being supported, she's still providing a child to us to be able to provide services.
And I believe she was 40, a 30-year-old woman. Why was she suicide?
I can't.
Katie doesn't work for Hope Counseling anymore?
I'm not privy to that.
Okay, are you aware that I put in the text messages between Katie and I? And Katie told me how Preston was with Alyssa the weekend of December 6th to the 9th when he acquired that burn on his back. Can you repeat your question? Are you aware of his text messages? Have you seen those text messages?
I have not seen any text messages between me and Katie.
Okay, I think that's in for trial. If Stacy, you're going to subpoena Katie to trial and testify in your case in chief.
Okay, so Crystal, do you recall a conversation when you told me with your fearful for Preston's safety with Alyssa?
Yes, I do remember that.
And the teachers were fearful also, and she was showing up to the school hysterically and crying like they wanted to.
When it was around court time, yes.
Could you give us some more, hang on, could you give us some more context, Ms. Whipple, in regards to that? Okay. Could you give us context to that?
When I had spoke with the school, they had stated that Mom was coming to the school crying a lot, and they were really worried about her mental stability at that time. I indicated that I understand what they were talking about, so it was coming up. Mom's really worried about it, and she really doesn't know what's going to happen during the court case. And so the school was really concerned and upset about her coming to school crying every day to pick up Preston from school.
And what specifically were you fearful or concerned of? Her parenting of Preston or her own mental state?
I was concerned about her own mental state at that time because she was crying a lot and she wasn't getting her own individual therapy at that time.
And Preston also showed up after the court, during around that time frame, I believe it was January 31st, he showed up with marks and nursery things on his arm. Krista herself told me that yes, she had called CPS back and was rather upset that they were closing the case on that incident. Okay. We're here to address the nail incident, and a lot of the history obviously has to be taken into context. There's a lot of she said going on. I think this will be a credibility issue at trial. I think really that's the kind of decision that's going to be made by the trier of fact. The judge ultimately will decide who is more credible and piecing these allegations of facts and circumstances together as to, allegations of abuse and neglect regarding the child. And yes, certainly, everybody is on edge in terms of either having visitation as a minimum or actually having custody or losing custody, depending on credibility. The only way that this family feud I could see would resolve if they settle this out of court, but it doesn't appear. This is why we're deep into trial. It doesn't appear that there isn't any immediate solution to settle these matters. And every time a new allegation comes up, they're rushing back into court, and it's one of those words. It's coming back more frequently. And the question is, the court's main concern, obviously, is if any of this court stuff is going to be impacting Preston, not only the actual contact and the visits, but the constant conflict that he may not be directly exposed to, or who knows who's telling you what in each of your households. But based on what I've heard, I think it's ultimately going to be a credibility issue. There's a lot of questions in people's minds as to, okay, can we pinpoint when those burns occurred and who cared for the child, if we can pinpoint when those burns occurred. And that obviously is going to be a big issue at trial, and it's going to turn on any of that evidence that Stacy might be referring to, those text messages, and Katie's willingness to testify, and Katie's credibility, obviously. But we're here to determine, as of today, everybody knows that this court issued a 6-month hiatus in terms of Preston continuing vigorously with therapy, intensive therapy, so that he can, at the time of the last day of trial, he was in a period of severe instability. So the 6-month purpose was to stabilize the child. We did not have you at the last hearing, Ms. Whipple and Ms. Hartman, but I already went ahead and made the court decision to resume the visits based on either what I've heard or what I haven't heard, or haven't heard any complaints, and Mom did cooperate and bring the child for the first weekend visit. I don't know if we're able to see the photos of the weekend visitation, because therapists don't have access to the filings of the court. So give me one moment. Would it be under, where's your exhibits? What's your file date? Pictures. Okay, so 1 moment. let me see if I can expand this screen and just show these pictures to the therapist. Let me share this.
Can I say something while you say that? We haven't had any contact with Preston in the last 6 months, right? So aside from that, we had one weekend, which that's what I showed you what we did. His older brother was out there. Even his older brother noticed a humongous change in Preston. His like that boy in the middle? Yes, that's Ethan. He's 13.
Okay, I don't quite remember Ethan, but I know there was a sister. Probably she's out of her teens now, I'm not sure.
No, he had one brother, which is Ethan.
Sorry, I think that's Mary Ann's youngest child, maybe.
Yes, her youngest child is 23, which this is her, right. So, we had one weekend with him. Anything that he's reporting to the counselors are coming directly from Alyssa.
This is the very first weekend. Yeah, welcome home, welcome back for him.
Yes, we bought him up.
This is the family courthouse now. I think I recognize this one.
This is family court.
The family courthouse. That's
right. This is his cousin Kylie, his brother Ethan, his other aunt Emily, my mom. And then we went to the pool at Emily's house, my sister's house, and we barbecued and played games. And then the next weekend, we went to the lake, and then the next weekend, not the next weekend, but the next day we went to the lake. We had a fun weekend. When he's with me, I don't discuss this case. I don't, I read that and I know what he's going through at home with Alyssa, so I try to be a positive outlet for him. That's his cousin Kylie.
Your daughter?
No, my
sister's daughter.
Yeah, and my mom brought him with him back to the room. We're all very happy to see him. We love him very much. And speaking of which, today, 3 years ago, we buried my brother today. He should be able to celebrate and honor his father with his paternal family instead of going through this,
Is that from at your house?
This is one of his rooms. This was initially my guest room. The other room is downstairs, but I moved his clothes and he sleeps in that room.
You went canoeing?
Yes.
Okay. And then you went on a boat?
We rented a boat and we did the tube in the back.
Okay, a picture for that.
I think scrubbing, maybe?
The brother brown. Was that a community pool?
Yes.
Yeah. Who's that?
That's his other aunt, Emily.
Is that the
Mary? Right, that's Mary Ann's daughter. We're a happy family. We do things together. We all get along. We love each other. And this is her making this accusation. She falls right in line with what I was saying in my last part here, with the findings that Bob said that he's being coached to make accusations against. Now it's me. First it was Sean for many, many years. I have the whole page of the CPS table of contents supporting this. Then for the last years, it's Mary Ann. Now, because I'm a member of the custody, all the allegations are going to be against me. I don't know too much about me, but just a little background. I don't have any mental illness. I don't have any drug issues. I've never had violence or anything like that. I work for a U.S. governmental agency. And with that being said, there are an extensive background check and character check that I have to go through in order to get this job. So,
contractor or a GS level?
I'm a contractor. It is a GS level position. I have a clearance and I have a government issued ID.
Thank you. I don't want to extend the hearing, obviously. We want to resolve this motion. It's temporary orders, what we're doing. I want to give the opportunity now to Ms. Hannah Hartman. Unless Ms. Ripley had anything further to say in response, other than you treated Preston for over a year. Mom never gave you a hard time. She was punctual and cooperative in bringing the child for visits. And anything you asked Mom to do, there were times she may have disagreed, but she and was reluctant, but she followed your advice.
Yeah.
The only thing I want to add is that in the last 6 months when I was treating him after the court date from February, he stabilized and he was doing very well. There was no self-harming behaviors, there's no actions, no thoughts. He really, really succeeded through his trauma therapy, and that's the reason why I transferred him to Hannah Hartman, is because he had succeeded and successfully completed his trauma section of his therapy, and I transferred him to Hannah because she specializes in what's called therapy.
And what point did he make the consideration that he was stabilized with the trauma therapy?
In June, he had completed his trauma therapy, and that's when we had talked in ACCA counseling about let's transfer him over to Hannah. We had been talking about it for a while. Once he did complete his trauma therapy, that we would transfer him over for some attachment and bonding with Hannah Hartman.
Okay. And can we add to that? That's just for the terms Alyssa is the one. See, she's trying to set us up. So with that side of the picture, she knows she can't do this type of stuff. So she has to be on her best behavior. But not only that, how does anybody know if he does have marks on him? During the time that Crystal was physically seeing him, he acquired, I think, 7 burns. I can go through it and show you the dates on that. And so Crystal had you been having in-person visits with Preston?
Due to COVID-19, I haven't been having in-person visits. I've been having virtual visits, so I've been seeing him virtually over the computer.
Yeah, another little thing about you still see him in this referral just to check up on him? You coordinate with Ms. Hartman?
I don't see him. Once the case gets transferred over, it stays with Hannah.
Okay. All right. Yeah, I would also like to bring reference to, you had stated in the orders that he was not allowed to change counselors. So I don't know why they're switching him around. Hannah's one person that you're not familiar with the case and the history of this. Not to mention, he's just repeating everything coming directly from Melissa. I've never spoken with him. I've never seen her prior to today when I see her on video. And going back, Preston had burn marks while still seeing Crystal on April 18, 2018, May 10, 2018, June 7, 2018, June 14, 2018, August 9, 2018, and August 23, 2019. The only burn mark that Crystal saw was the December 9th burn mark, in which she told CPS that he came directly from my house. Now she's not even seeing him in person, and this is her assessment based off of Ms. Hartman and Ms. Whipple. Neither of them are forensic evaluators. If if there had been a request for a forensic evaluation, it would have been done by the time of trial. And as far as getting the child's entire history, she is within the same office, so it's not really a change of passwords. It's the same office that's still providing the needs, and one person is better suited to address a different set of needs. So if Preston was done with trauma therapy, I wrote it there in the chat box. Ms. Hartman is there for attachment and bonding therapy between the child and the mother. Obviously, they might not know the entire history, but they have their own file notes, and they are not forensic in type or any nature. And what their main concern is the therapy and the attachment therapy. So, when did you first meet with Preston, Ms. Hartman, when the case was transferred to you?
Judge, I met with him in June. I can look up the exact date if you'd like.
Sure.
Okay, let me find that really fast so I make sure I have the exact date.
And I hope I'm spelling your last name right in the chat box here. Is it 1 N or 2?
It's 1 N.
Okay, good. So when was the first clinical visit?
The first time I met with him was June 12th.
And was that virtual or?
It was through telehealth. Yeah, our office hasn't resumed in-person services yet.
Okay, so it's like a Zoom video, basically.
Mm-hmm.
Yeah, video. Okay. And in preparing for that visit, you had a thorough history from the file and from this record, obviously.
Right, so I have access to all of Preston's documents, assessments, notes, since he started therapy at Hope Counseling. And Crystal also completed a transfer summary for me, so I was up to date on the most recent kind of updates on the case, and reasons that she was transferring him to me was to do their play-based treatment.
Okay, and is it once a week intensive or twice a month?
It is once a week, family therapy, once a month, parent-only sessions, and individual as needed. So TheraPlay is a family therapy, caregiver and child model for the most part.
Correct. Okay. Were there any resurfacing of any trauma issues recently since you started, I would say almost 3 months ago?
Yes, yeah. So on August 14th, I met with Preston and his mother. Preston, I actually met with him individually because Alyssa told me that there were concerns about him being coached to hurt himself, and so I asked Alyssa to step out. Preston wasn't present when Alyssa told me that, and then Alyssa brought Preston out of his room into the room that they had the computer to meet with me, and then she left that area. I saw her leave in the door that was behind them on the computer, and Preston had to go get her after I talked to him. And that's when he told me that Auntie Boo Boo told him to get a nail and a hammer and hammer it into his skin.
Okay. And Auntie Boo, is that a V? V?
Yeah, V-O-O-V-O-O.
Yeah, I did spell it.
Okay, that's how he had spelled it to me in our session. And he told me, so it's a paternal great aunt, but he described it as his aunt's aunt, right? So great aunt. So that's how he described it. And then in the following week after that, I did a therapy session with him and his mom, and he demonstrated really different behaviors. So I had been meeting with him for a little over 2 months at that point, and his behaviors were significantly different in this therapy session. It appeared that he had some hyperarousal, which is a trauma response, and that is demonstrated through hyperactive behavior, difficulty calming himself. He had pressured speech. He was yelling. He's very hyper in general. He's a really energetic kid, but it was very different in how he was talking and presenting himself was very different to me, even through telehealth, right? Sometimes it's hard to see a client's affect and to really get a full picture of their behaviors, but he was significantly different than when I had seen him prior to that, and that was a full week after his visits.
You had a full week around the same time you had a birthday, is that fun? Hang on. I'll give you time. I reserved this afternoon for this case, okay. How many visits did you see? Was it like a one time? Was it isolated?
This was after his first visit. After the court resumed visit, he had only had one visit at that point. Also, Jay, sorry, I do have a therapy session at 3. I was only able to block out my schedule until 3 p.m. Is it okay if I leave at that time?
You can, yes, certainly. You have to meet your appointments. Okay. So the next visit, child had a hyperarousal, the trauma response, difficulty calming himself, speech was different, and that brings us up to date. You've only had that one visit, which...
No, I've had more sessions since then, but that is the only visit that he demonstrated that sort of trauma response.
So those following
other sessions, he's had that.
No, he hasn't had that.
He hasn't had that in the last 2 sessions that I've seen him.
Okay. No, they're telling me that the paternal family did not get their last 2 weekend visits, I believe.
Yeah, Kirsten reported the Aunt Boo Boo incident because I'm a mandated reporter, and
okay, did you have a question for Ms. Hartman?
I do. This is my point. All of the abuse, all of the issues are stemming from Alyssa. And she's trying to set it up so where it looks like the paternal family, even though these burn marks occurred during her time frame. And so she does not want us to be involved in custody growth. She's made that clear. All the way dating back to 2014, she made it clear, and the last time she took the stand on the court, she was with her that date back to 2013 with my mom, with Marianne. This is stemming from her. She's acting out, saying if you give us back our visits, she's going to hurt Preston and do this to Preston. It starts with her. It's all Alyssa.
Okay. Alright, do you have any concerns that the court has to decide today, Ms. Hartman, if visits should resume with the paternal family member? Not obviously, I'm not delegating my judicial authority to make decisions in the best interest of the child. I have to piece everything together. But from the therapist's end, in terms of keeping a child or stabilizing a child, do you have any reason to believe that paternal visitation or contact is impacting the child's changing behavior? And
Based on
okay, I guess I didn't want to put you in a position of finger pointing, but something, obviously, there's a change in Preston's life after 6-month hiatus. It may not necessarily be critically that the paternal family doing anything, but is a child, capable, whether consciously or unconsciously, with a change in behavior just with this resumption of contact. Remember,
Mr. Judge, we still want to make note that it was a week after my visit. A week after the visit. So that's well enough.
Every weekend, right?
Yes, but it was August.
Sorry to interrupt. Significant trauma responses would definitely appear a week later and typically longer than that, potentially 2 weeks later or longer, depending on the significant trauma reaction of the child. So it's not like bizarre at all that Preston would still be demonstrating a trauma several weeks after a visit.
And did he have the bump on his head at this point?
So this is all through telehealth, and the last time I saw him, he did not have a bump on his head that I noticed, or he did not during the hyperarousal visit.
That was the last 14th visit? That was the last visit?
That was, no. The August 14th visit is when he reported about Auntie Boo-Boo.
The hyperarousal, yeah.
The hyperarousal was after that session. It was another week after, so it would have been August 21st.
Wait, I'm confused. Okay, so August 21st was when he diagnosed the hyperarousal.
When I observed the hyperarousal.
So August 21st, that's 2 weeks after my visit.
Yeah, and he had strange behaviors August 14th as well, but it was a shorter time with him, and he was describing what was potentially traumatic content about being told to hammer a nail into his skin, and so hyperarousal on both of those visits is not strange.
Okay. Alright, any questions for the mother's attorney? Ms. Hartman. I'm not going to put Ms. Hartman in a position, obviously, of pointing fingers. It's just the change of the environment, which the court obviously made a decision with, and Ms. Hartman and Ms. Whipper was in at the last court hearing, on this, I guess, on, whatever motion was then pending. I made the decision to, monitor it closely, but resume the visitations. You saw the pictures from the visitation, and without pointing fingers, but this change in schedule and environment for Preston, we believe, it's been impacted because of the resumption of the visitation without pointing fingers, like the fact that he has to visit with his paternal family.
based on Preston's report, he was told by someone to hurt himself. So I do not know who Auntie Boo Boo is specifically, based on his conversation with his guard, with Mr. Cercio. It sounds like it was Stacy, but he didn't tell me that specifically. Based on what Preston said to me, I would recommend that visitations be stopped, at least non-supervised visits, or that he's being coached there.
He did not disclose to the hire the CPS worker who Auntie Boo Boo was. Who I think all he said there is a 99-year-old lady, or maybe, I don't know,
Preston is very difficult to build trust with. He's pretty resistant, and so it could have been a lack of trust. Children have a hard time building trust with CPS workers at times, and so he may not have trusted her in the first interview, but they're maintaining a relationship and communication with her. He could build that trust and open up more. I don't know how he would, it could have been.
We've been around for barely 3 months. And he's barely known Mr. Cercio, and he made some type of statement. How old is he now? 79? How old is he?
He's 7.
He's 7, right. At his age, and not knowing you for a long time, Mr. Cercio for a long time here, having got a new CPS worker on the case, is that age appropriate and for a 7-year-old to make statements or make confusing statements, make statements to please people, or would they make a statement because of the trauma? I'm not a therapist, so
it is age appropriate. That he will, make statements to strangers at times. Preston has built trust with me, right? He's with his mom and me in our sessions, and he's clearly gotten more comfortable in different areas, and being able to talk to me more than he did in our first couple of sessions. And as Mr. Cercio said, he was much more talkative and friendly and open this time, and he didn't appear coached. As far as concerning visits with the vet, it sounds like she's had one conversation with him, and so it's not that he just may not know if she's protected or not. He doesn't know who she is or what her role is all the time, and it's hard to understand that. And so he may not be sure what kind of power she has to be able to help him, or if he tells her the truth, what she'll be able to do with it. And so he could be telling false statements at different times. It kind of depends on him and his level of trust that day and with that person and how he's doing. And so he's, with Mr. Cercio and I, he's had a few months to build trust with us. Whereas Yvette, he's had one visit.
Okay, thank you. It was not perfect. If you really have to just sign off and go, just hang up at any time, and we appreciate the time.
What Preston was saying, and here, Bobo is my grandmother, and I don't know my grandmother, she's right here. The last time we saw her or spoke with her was Easter of 2019. It is. She lives in California.
How do you spell her nickname?
B-O-B-O. It's grandma for Portuguese.
And it's your
grandmother? The same is my grandmother, and that would be Preston's great-grandmother.
So you call her Grandma Bobo?
No, I call her Bobo because that means grandma in Portuguese. And so I call her Bobo. And that's her, the last time he saw her or had any contact with April of 2019. And she is 99 years old. How do you know that? I don't know.
And she lived in California, you said?
Correct.
And it was April 2018?
2019.
19?
Yeah, she came out to visit me. Visit us.
And where in California?
San Diego.
And where?
San Diego.
San Diego. Okay.
Your Honor, I'll just say that, and I have never referred to myself as Bobo, Auntie Boo Boo, nothing. My name is Stacy, and he calls me Auntie Stacy.
Okay. Ms. Hurdick, did you want to say something, and then we'll get to some rules?
Yes, I believe they said that there was like anti-Guru going on in Stacy early on with kids. There was like anti-Guru that was going on. How would you say it? Do you know anything about that name? All of a sudden there's a drama about that name that I found that disingenuous. They should have.
So there's not excuse me for 1 moment. I don't want to have to mute you. Ms. Hurdick, finish up, and then I'll mute Ms. Cantor.
Well, I just find it interesting that all of a sudden at this stage in the hearing after there's been testimony by the therapist and TPS and Mr. Cercio that Stacy all of a sudden knows who Auntie Boo Boo could be, and she said there was nobody by that name. I find that disingenuous and that there is somebody there by that name, and that puts a little bit of credibility as to what the child is saying.
Your Honor, for sure, there is no Auntie Boo Boo. There's no great aunt that exists. I was never, when I talked to CPS, I said there was a baby over and a grandmother. There is no great aunt. He doesn't have a great aunt. And again, I've never referred to myself as anything other than Stacy. Okay. And I do see that Yvette Howard, I believe, is still listening in on this call. And I was wondering if she had any clarification questions based on what she's heard in the past hour and a half, I presume, or hour and 15 minutes. Let us know, Ms. Howard, if you had any further questions that may assist with your ongoing case.
I'm listening to everything, and it's just a mishmash. Like I said, it just seems, again, yes, I did only have one meeting with the child, but what he told me is different than what he's telling others. And as far as this boo-boo, that's what he told me. It was Auntie Boo-boo. He specifically stated that she was a 99-year-old lady, and that was his great-great-aunt. At no time did he ever state that it was Stacy. When he referred to Stacy to me, he always referred to her as Auntie Stacy. That was it. Even when he said that Auntie Stacy saw what Boo Boo did, and Boo Boo was the one who told him, it was always Aunt Stacy. And with clarification, I did get clarification from Miss Stacy that it was a Bobo, but I was going with what we had in the report, which was, it was stated as a Boo Boo.
Thank you for clarifying that. All right, Mr. Cercio, you've been listening intently on this hearing. Anything that you may have thought of or you wish to add based on, you had the one contact before you knew that you were made aware, obviously, this case was coming back to court, and so I presume you had to scramble in trying to get a interview with Preston, your client. Is that correct?
It took a couple of days to get it set up. But we managed to get it in by Friday, actually, I want to say at the noon hour. And he didn't seem much different than the last 3 times that I saw the child. He wasn't any more or less agitated. But the only one that really stood out as being remarkably different was interview number 3, where he told me that he had a secret to tell me, and he made a correction about telling the truth in front of his maternal grandmother, who was in a room at the time. Other than that one event, which felt coached, everything else has felt genuine and consistent with what he's told me. Although, as I listen, I think you're right. It is a credibility call because he's telling me one thing, telling Ms. Hartman something else, telling CPS a different story. And I don't know how to. I'm not quite sure what he, as the trier of fact, is going to do with that information because it does seem to be going in a couple of different directions. He was very quick to say anti-Ruger is anti-Stacy. Said it kind of quickly, and then almost in the same breath, I have to feel, again, what the leader said as before, and I said, no, she's not here. Can I talk to her now? Can we go to lunch tomorrow? He seemed to want an immediate contact with her, which runs contrary to the prior statement that he made not a minute before that. So I'm like everybody else in this. I don't know what to do with the statements, and maybe there's an objective testimony to get to this, but I'm glad to keep meeting with them to continue what relationship I have with them. He seems relaxed with me, but it's a head scratcher.
You are his voice. You are to obviously report back to the court what he's, he's telling you as if he was talking to the court. So not any kind of advocacy role, just let me know if he were asked something, what would he say? What would Preston say?
And to boil that down, I asked him point blank, who's anti-Ruger? Oh, that's anti-Stacy. It was that quick.
And you were able to see his demeanor on the video.
Yes.
Was it nonchalant? He didn't fidget or show any kind of hyper-arousal responses?
Well, he was his usual thought, which is, I'm going to pick up my phone. When he talks to me like this, he can see me and do it for play games with the edges of the camera. Okay. And he's that sort of playful with me, or spinning around with the chair. I'm invisible, I'm visible, I'm invisible. That's what 7-year-olds do in offices. And it was, it seemed a no-filtered response, very casual. Oh, that's anti-Ruger. And then he kept on talking. Can I have lunch with her? Can I see her today? But all of this ran very much in a stream of consciousness. There didn't seem any premeditation or hesitancy in his words when he offered the information.
Bob, can I ask what date you met with him?
Just past 12.
The 4th. Okay, so I had already sent in my motion saying that there is no anti-Ruger, whatever you want to call it. That's well enough time for Alyssa to manipulate. I brainwashes him. Even his 14-year-old brother noticed changes within Preston. He's a completely different kid. He's repeating stuff that only adults would know. He doesn't know certain people's names within the family. This is what she does. She's coaching, moving into assessment before. You also remember that he does not trust anybody. Why would the counselor still on the call? No, we had to talk off. We had a clear call. And I personally find it very unusual for a 17-year-old to be aware about trust and having trust issues. To me, that kind of speaks that somebody that rights or whatnot. So, I mean, those two things are not my words. The words that it happened in the letter are like. Right. I'm not saying you said that. I'm saying my interpretation of a child having trust issues. That's what it speaks to. But you met with him just recently. I had already submitted my opposition, my pickup order, in which I had put that information in there. So that's well enough time for Alyssa to, have him repeat what she wants him to repeat.
And this is, again, the whole basis of this custody issue is she was burning him and beating him because she was not at him. She was jealous of the attachment and the bond and the relationships that Preston has with myself, Marianne, and our side of the family. And I believe it initially started with she can't control her emotions and her, when she gets violent, is stated in the previous CPS history. And now, since we started making allegations, now she copied us and is turning it around on us and coming for us to prevent us from having visits with him.
It begs the question, I have to ask this, Stacy, the question's for you. You guys waited 6 months, we were on a hiatus. I reinstated your visits, and, we're in the middle of a trial, in the middle of court proceedings. It begs the question, you get your visits reinstated back. I mean, I'm a common sense person. I'd say, well, let's just show as much fun as we can, have a lot of fun with Preston and show him, a lot of love and catching up with the family. You know what I'm saying? Well, it begs the question, and I get it. I get all the finger pointing and, like going back and forth, when you just got your visitation back, and you're pins and needles, obviously, you just want to make everything fun for Preston, etc. And how soon did you find out CPS was knocking on your door, following you?
Exactly. We got our visits back. We were happy to see him. We had fun that day. Approaching my next visit, I believe, actually, I didn't find out CPS didn't call me until recently, but when they called me, I think the Thursday before I was supposed to put Preston up. So that's almost 2 weeks after my initial visit, this allegation comes out. I'm telling this.
Okay. Right. Begs the question. You just got your visitation back and an incident happens and then a lot more finger pointing is happening. That or Preston has a imagination, but it doesn't seem in line with what the therapists are saying. He exhibited signs, but I didn't get to ask the question. The severity of the hyperarousal traumatic responses. It appears that my finding today, there was one showing of that, and because I guess mom and her attorney stopped the visits, obviously there was no more showing of the traumatic responses, and that's the problem when you have you have court and then you have the child's mental health. So you have to, I guess, do what you do, or the other side has to defend, and then they want their compensatory time. Based on what I'm hearing, Hannah Hartman, I guess, her last statement for purpose of today's hearing was to recommend supervised visits, but I'm getting a contradictory statement from Mr. Cercio saying, he said, it was Auntie Stacy, but when can I see her again? So, no doubt, if you weren't seeing your child for 6 months, you're going to plan a lot of fun activities for the child, a lot of bonding and catching up with the paternal side of the family, and so they're not just going to sit around the house, they're going to be planning lots of activities for him. And I need to ask also about his school. Mr. Cercio was of the impression that he's not attending his virtual school. And then I'll get to today's rulings and we'll wrap it up. Let's on the school question, Ms. Furtick.